Hello everyone, I'm going to discuss with the topic that is Doctrine of Caveat Emptor. It's very important from the Sale of Goods Act. Without this doctrine, your whole paper will not be completing. So these doctrines are always important. And this is the topic which I'm going to speak that is important from the examination point of the CA, foundation business law paper as well as the LL.B students. So let's begin with the topic Doctrine of Caveat Emptor. So the Maxim Doctrine of Caveat Emptor means let the buyer beware. That means buyer should be aware before going to purchase the goods. He should be careful about the goods which he are going to choose and judging his mind to purchase the goods. Now according to this maxim, what the law says we will say. So it is the duty of the buyer to be careful while purchasing goods of his requirement, and in the absence of any inquiry from the buyer, the seller is not bound to disclose every defect in goods of which he may be cognizant. So this maxim, it says that duty of the buyer's duty is there. He should be careful while purchasing goods of his requirement. That means he want the goods for his what purposes he want. He should be careful to purchase. Then seller is not bound to disclose. Seller is not at all bound by the law to be disclose the defects lies with the goods which he may be cognizant. That means he may be well aware also, having a knowledge also this is the defective goods, even though he is not bound to disclose to the buyer, because the rule says Doctrine of Caveat Emptor. And again this explanation, it says the buyer must examine the goods thoroughly and must see that the goods he buys are suitable for the purpose for which he wants them. If the goods turns out to be defective or does not suit his purpose, the buyer cannot hold the seller liable for the same, as there is no implied undertaking by the seller that he shall supply such goods as suit the buyer's purpose. Now this explanations of this doctrine, it says that buyer has to examine the goods thoroughly. He must see it. Each and every corner of the goods he must touch it, see it. And he also should see like this, that he buys the goods for his purpose for which he wants. He should see that it will be fitted to his purpose or not. And if it is defective, that goods turns out to be defective and does not suit his purpose, then buyer cannot bind seller on this point, because there is no implied undertaking by the seller. Seller has not made any implied undertaking. He has not taken that he supplied the goods to the buyer of the buyer's suitable purposes looking to it. It will fit the buyer's purposes and he will supply the goods like this. It was not an undertaking taken by the seller. So this is the rule says Doctrine of Caveat Emptor. That means in each and every point the buyer should be careful about it, how to purchase the goods, and he should be looking to the that is looking to the characteristics of the goods or the suitable purpose. It will suit it to his purpose or not, he must see it. Now to clear it these points, we are going to put one illustrations over here. So first illustration we'll give. Suppose A purchase a horse from B. He has purchased a horse from B, and A makes needed this, makes it known to the seller. He should makes it known to the seller, but he why he need this horse. So A, why he needed this horse, he should disclose to the buyer. So of course the horse he required it for his riding, but he did not communicate these facts to the buyer, to the seller. So horse is not suitable for his purpose, that is a riding. It was only suitable for being driven in carriage. So the caveat emptor being the rule, he cannot claim that he wanted to reject the goods, or he cannot also claim compensation from B, because A has asked for a horse which is he required for his riding, but he did not mention that this particular purpose specifically why he wants the horse. He did not mention to the B. How B will be aware that what kind of horse he wants, because there are various horses are there fitted for the purpose. So that's why caveat emptor the rule applied, and that's why buyer should be careful about it. So let the buyer be when it should be applied, and that is why he cannot reject the goods, and he cannot also claim compensation from B. There is one more case law we can discuss here, Ward versus Hobbs. So the facts is that the case of the facts is that the certain pigs were sold by auction with all faults. So auction is made, and this with all faults the auction is made. The pigs were suffering from typhoid fever, and all of them but one died. All were there, but among bulk of the pigs, only one died. So they also infected a few of his buyer's own pigs. So the same pigs, when buyer has picked up, when purchased, and kept it with the pigs of his own. Earlier he was having some pigs of his own, so he kept it with them. So when the suffering typhoid fever suffering pigs were also been together with the buyer's own pig, then definitely that pigs will also infected, because this typhoid fever is a contagious disease. So all the other remaining pigs were also been infected. So this is the case, the decision how the court has made. We will see it, that the seller was not bound to disclose that the pigs were unhealthy. So that was not a duty of the seller to tell each and every defects of the goods, which he may be aware, as the rule says. We have already studied, that is the law point we have studied, what the doctrine says. So caveat emptor being the rule, the buyer could not claim damages from the seller. The seller is not bound by law to disclose, so that is why the buyer could not claim compensation from the seller. Now we know that one thing, when there is a law there is an exceptions, because we cannot survive with the strict rules and rigid law. There must always be some relaxations, flexibilities has to be made to suit the needs of the society. So that is why exception is there. So what is this exception is given? We have to see it. So to this doctrine, the following exceptions are available. Now first exceptions we see that where the seller makes a misrepresentation and buyer relies on it. So the doctrine of caveat emptor does not apply. Such a contract being voidable at the option of the innocent party, the buyer has a right to rescind the contract. So this is seller makes a misrepresentation. So this is a misrepresentation. We caught it in the Law of Contract Act, that is the free consent chapter was there. That is one of the ground was that the free consent. That is why contract was voidable, not a void one and valid one. It was voidable. Voidable is always two options is given: either you can accept or you can cancel the contract. So this is on the point that the voidable one, and the buyer relies on the misrepresentation because he might have misrepresented the goods to be purchased. Okay, you will be fitted to your purpose and take this is the best one, and something or the other challenges he has made. So on relying on that, he has purchased the goods, and the doctrine will not apply here. And the contract is voidable at the option. That is why buyer have a remedy. Either he can accept the goods or he can cancel. So he can cancel. He has a right to cancel the contract because it was misrepresentation was made. And the second exception is where the seller makes a false representation amounting to a fraud, falsely representing it. That is why it is a fraud, and the buyer relies on it. So buyer relies on whatever he stated, whatever the seller stated, he relies on it. Even he has made a fraud on it, so he relies on it. That is why where the seller has actively conceals defects in the goods. So seller by this way he has conceals some defects were there, but he had conceal it, hide it. So goods, and it could not So the buyer could not, discovered on a reasonable examination, because some defects are there which is hidden one, and how can you examine it by your bare eyes? By looking into the goods, you cannot examine unless and until seller will tell you. So that is why what happened on reasonable examination, how you could not can discover, you could not discover. That is why the doctrine of caveat emptor does not apply, because fraud is made. How can you apply that? Because you did not get a time. You have no chance to go for an examining the goods. Such a contract is voidable at the option of the buyer, and the buyer is entitled to avoid the contract and also claim damages for fraud. He can cancel it or he can ask for compensation for fraud. And the next exception is where the goods are purchased by description as well as the description, and it must correspond with the description. Then when description is made, then you must correspond with the description, right? So when you made the purchase the goods, and you have said that the given a description of the goods you want it, and it does not correspond with the description according to the section 15 of the implied conditions, then where the goods are purchased by description from the seller, and in fact the seller was dealing with such a kind of a class of a goods he was dealing with, and then if doesn't correspond with the description, then of course this doctrine of caveat emptor does not apply, because you have already made an description is given, that is the seller must be aware that okay, I should supply the goods according to the requirement given by the buyer. So that is here in this case the doctrine of caveat emptor does not apply, and the seller cannot apply this, and that is why buyer has examined the. And suppose if you have given a chance to examine the goods, suppose buyer has examined the goods, but if after examining it also he could not discover the defects in the goods as per section 16 clause 2 of the sale of goods act, then definitely the doctrine of caveat emptor does not apply, and seller must see it that it must according to the description, and also he must give the goods of marketable quality. If he does not give, then doctrine of caveat emptor does not apply, because he already spoke about the description of the goods to be given. So this is the exceptions we have to give under the doctrine of caveat emptor. And one more exceptions we will give, that is the fifth point of exceptions, that is where the goods are brought by sample. The doctrine of caveat emptor does not apply. Why? Because you have made a sample is given, so according to the sample, so buyer has ordered the goods, and you have taken the goods as per the sample. And here the exception is such that after given to the sample, you have taken it, but it should goes according to the sample. But the seller, if does not supply the goods which goes with the sample, then of course there will not caveat emptor will not apply, because when he wanted to check the goods with the bulk with the sample, he was not given an opportunity to examine it. And if there is any hidden defects are there in the goods, then how can you examine the goods? It is not possible. So that is as per section 17 of the that is Sale of Goods Act, that is says about the implied conditions. And the next exception is where the goods are bought by sample as well as descriptions, and the bulk of the goods does not correspond with the sample and with the description. So buyer is entitled to receive the goods, that is section 15. So here two things apply, sample as well as description is there, and the bulk of the goods, the bulk you have purchased, that should be also correspond with the sample as well as description. Then the buyer is entitled to reject the goods. If it does not correspond with that, then he will again entitled for the rejecting the goods as per section 15. Now exceptions 7 point of exceptions, where the buyer makes to next known to the seller the purpose for which he requires the goods, and relies upon the seller's skill and judgment, but the goods supplied are unfit for the purpose for which the buyer wanted. The principle of caveat emptor does not protect the seller and he is liable in damages. That is section 16 subsection B says. Now, where buyer has makes known to the seller, he has already communicated to the seller the purpose for which he wants the goods, and relies upon the seller skills and judgment. But the goods supplied are of unfit for the purpose or the specified purpose for what he wants. So that in that cases or in the circumstances, principle of caveat emptor does not apply, and by this seller cannot protect also take a defense of the caveat emptor. Of course he is liable for compensations to the buyer, because why he said he already buyer has already made known to the seller that I want this specific goods for specific purposes, and the seller has already said on this point, he said, okay, take these goods, it will be fitted to your purpose. So buyer might be thinking seller has applied his skill, judgment, all knowledge, all conversions, quality of the goods, he has already judging it and said that you take these goods. So of course this implied. That's why caveat emptor will not apply, and seller cannot take the defense of caveat emptor. And the last exceptions, that is the 8th point, where the trade usage attach an implied condition or warranty as to quality or fitness. So trade usage says that there is an implied condition or warranty on the part of the seller as to quality or fitness, and the seller deviates from it, that the doctrine of caveat emptor does not apply and seller is liable for compensations or damages. Section 16 clause 1. So as per section 16, it says you have to maintain the quality of fitness. It is implied. The law says that it is implied. Always the goods should be of good quality or fitness must be there. So seller is reluctant to provide or complying with these two. Then doctrine where it will be applied? Does not apply. So that is why ultimately if seller is not maintaining this, then seller is liable to pay for the compensations to the buyer. So this is the topic which is important from your examinations from the point of view of the CA Foundation Business Law students as well as the LL.B. And I am sure that this is the topic which is so important, and you can anything ask from this doctrine or the maxims, you're damn sure that you can write any point of any angle they ask you, you can very well present your paper. So I think so you can attempt these questions in very good manner, a good presentable paper you can make it. So this is my request to you, watch this video till the end, and any suggestions you want you can just comment it in my comment box. And I'm coming with a next video with also the next maxim will be the noun non-habit is a very important maxim from the examination point of view for the business law as well as the LL.B. papers, Mercantile Law paper. So if anyone is new to this my channel, please subscribe to my channel, and I'm always coming with the most recent videos and the good very knowledgeable and very conceptual topics I'm coming with. So till then watch my video, and till the end you watch it. I'm coming to the next video, very important maxim.